This opening isn't about facts, it's about positioning. The father's side quietly signals surrender before anything even starts, and that sets the entire tone. When a voluntary relinquishment is already filed and the father isn't even present, the courtroom dynamic shifts instantly.
All right, and Ms. Sapien, I got the message why you need to be off camera, and that's fine.
Thank you, Judge.
All right. Okay then. Ms. Powell, then who's our first witness today?
And did I hear that Miss Sapien is in a time crunch?
I think we got
Yes,
several
I
people.
am.
I think she's in a time crunch. I think Miss Kincaid's going to be in a time crunch.
Okay, I'll be very quick then. My first witness will be Mel Tucker.
Ms. Tucker, you solemnly swear or affirm that you'll tell us the truth today?
Yes, ma'am.
All right.
May I proceed, Your Honor?
You may.
Miss Tucker, please state your name.
Mel Tucker.
How are you currently employed?
I am a child protection investigative supervisor for the Department of Family Protective Services.
Okay, and are you familiar with the case involving the child Jonathan Dubois?
Yes, I am. I oversaw the case.
Okay, and as a supervisor, do you regularly staff cases with the lead investigator?
Yes.
Do you also review the records in a case?
Yes.
Okay. Now, in regards to records, does the department keep regular records during the course of its cases?
Yes, ma'am.
Okay, and are those entries in the records made by a person with personal knowledge?
Yes.
Okay, are they made at or around the time an event occurs?
Yes, ma'am.
Okay, are the affidavit in support of removal and the investigative report made part of the department records?
Yes, ma'am.
And are you a custodian of those records?
Yes, ma'am.
Okay, and do you have access to review those documents?
Yes, ma'am.
Okay, and again, do you regularly staff the cases as they're being worked?
Yes, ma'am.
Okay, were you the supervisor over the investigator that was involved in this case?
Yes, ma'am.
Okay, and in regards to this case, who is the mother of Jonathan?
Ashley Dubois.
Okay,
Dubois.
and how?
I'm not sure how to pronounce it, but yes.
Okay, it's spelled Dubois. Is that correct?
Yes, ma'am.
Okay, and how did the department become involved in this case?
On April 20th, 2025, we received a report regarding mother and child being positive for methamphetamines at birth.
Okay. And did the department begin an investigation at that time?
Yes, ma'am.
And did the department have discussions with the mother regarding the positive drug screens?
Yes, ma'am.
And what did the mother tell the department?
She admitted to reoccurring use during her pregnancy, and she also admitted to using around the day that she delivered.
Okay. Did the department attempt to prevent the removal?
Yes. We were unable to do an FTM because she had no support, and we had no possible placement options to look at a parental child safety placement.
Okay. And so at that point in time, was it determined that for the safety of the child would need to be taken into care?
Yes, ma'am.
Okay. Now, where was the child initially placed during the time that you had the case?
With the paternal grandmother.
Okay.
And a kinship placement.
Okay, and that is the mother of Rashad McDonald, is that correct?
Yes, ma'am.
Okay, and then other than, did you have, did the department have contact with Mr. McDonald?
Yes, ma'am. My worker went to the hospital the day she made contact with mom to do an interview and complete a 3010. And then she went back to the Potter County to meet with him to go over removal paperwork. So she met with him twice.
Okay, so it wasn't possible for the for the father to take the child either. Is that correct?
No, ma'am.
Okay, other than kind of what you've testified to, and I know we've narrowed it down, did you have any other involvement with this child?
Not really, not after we placed and had the adversary.
Okay, I pass the witness.
You're muted, Judge.
Sorry. Okay, Ms. Kincaid, any questions?
No questions, Your Honor.
All right, Ms. Sapien,
No questions, Judge.
Ms. Zavala.
No questions.
All right, Ms. Powell, any further questions for Ms. Tucker?
Not if Miss Tucker and I'd ask that she be released.
All right, counsel, any objection?
No objection.
No objection.
All right, thank you, Ms. Tucker. Have a good rest of your day.
You too.
All right. Okay, who's your next witness?
Petitioner calls Jalissa Bird.
All right, Ms. Bird, if you'll raise your right hand, you solemnly swear or affirm the testimony you'll give us today will be the truth?
Yes, I do.
All right, you may proceed.
Thank you, Judge. Miss Bird, please state your name.
Jalissa Bird,
And how are you currently employed?
St. Francis Ministries.
And what is your position with St. Francis?
I'm a permanency specialist.
Okay. And are you familiar with the case involving the child Jonathan Dubois?
Yes, I am.
And you're cutting out. Judge, can she turn her video off to see if that helps?
Yeah, let's do.
Okay, can you hear me, Jalissa?
Yes, I can. Can you hear
So
me?
much better, thank you.
Okay, perfect.
Now, what is your position with St. Francis?
I'm the permanency specialist.
Okay, and as a permanency specialist, what do you do?
The second witness shifts the case from past events to future outcomes. This is where the real decision gets shaped. The father's voluntary relinquishment isn't just paperwork, it's a full legal exit. Once that's validated, the court no longer needs to evaluate his fitness, intentions, or capacity.
I work with families to mitigate reasons for removal and just overall work the case and a caseworker.
Okay, now the father of this child is Rashad McDonald, is that correct?
That's correct.
And did Mr. McDonald execute an affidavit of voluntary relinquishment?
Yes, he did.
Have you had the opportunity to review that relinquishment?
Yes, I have.
Okay, and does it meet all the legal requirements?
Yes.
Hey, did he execute the relinquishment on February 12th of 2026?
Yes.
And was it filed with the court on the same date?
Yes, it was.
Okay, now, St. Francis signed for the department to be named the permanent managing conservator of this child, but that's not what you're asking for today, is that correct?
That is correct.
Okay, are you gonna ask that father's rights be terminated, but the grandmother will be named the managing conservator, correct?
That's correct, yes.
Okay, I'd ask the court to take judicial notice of the relinquishment filed on February 12th of 2026.
Any objection?
No
No
objection. No, Your Honor.
Okay, I'll take judicial notice of it.
Okay, and again, are you asking that the court terminate the parental rights of Rashad McDonald as to the child based solely upon the affidavit of voluntary relinquishment?
Yes.
Hey, do you believe termination is in the child's best interest?
Yes, I do.
Okay, now in regards to the mother, once a case is sent to St. Francis, what steps does St. Francis take in doing the casework?
Yes, so we create a family plan of service. We create the family plan with the parents, go over the services that we're asking, hoping that the services will mitigate reasons for removal and just continue to work with the family and provide permanency for the child.
Okay, was a service plan developed in this case?
Yes.
Okay, did you have the opportunity to review the exhibits I sent out?
Yes.
Okay, and were you able to review exhibit number 1?
Yes.
Hey, did you recognize that document?
Yes, I did.
Was it a fair and accurate copy of the document?
Yes.
Were you familiar with the contents of the document?
Yes.
And had it been altered in any way?
No.
I'd ask to enter exhibit 1 into evidence at this time.
Any objection?
No objection. No, Your Honor.
No objection.
All right, it'll be admitted.
Thank you, Judge. Ms. Bird, what is exhibit 1 there?
Exhibit 1 is a family plan of service for parent Ashley DuBois.
Okay, and are you aware of whether the mother, Ashley DuBois, had ever had the opportunity to review her plan?
Yes, I believe so, with the previous worker, Erica Flores.
Okay. And to your knowledge, has the mother completed any of her services?
She has not completed services to my knowledge.
Okay. Would it have been important for the mother to complete services?
Yes.
And why is that?
Services are provided for parents to mitigate reasons for removal, and we believe that it would have been helpful to provide permanency to the child.
Okay, Ms. Bird, how long have you been on the case?
I believe I was assigned August of 2025.
Okay, now since August of 2025, had you had any significant contact with the mother?
I have not. I did go to her previous address and just continued to try to contact parent, but I have not had the opportunity to be able to meet or speak with parent.
Have you done any type of accurate searches or other attempts to locate Miss DuBois?
Yes, I have.
What attempts have you made?
I have done accurate searches. We also had a connection specialist. I have done monthly address checks as well as jail searches, internet searches, social media searches, and have talked to family and friends.
At this point in time, do you have any idea where the mother resides?
No, not at this time.
Okay, and do you know if do you have any idea whether mother could provide a safe place for this child to live?
Not at this time, no.
Okay, and is that based upon the mother's failure to maintain contact with St. Francis?
Yes.
To your knowledge, has the mother had any contact with the child?
Not to my knowledge.
Okay. Have you had conversations with Miss Nichols as to whether Ashley has reached out?
Yes, I have.
Okay, and what is your understanding?
Ms. Nichols has stated that she has not had contact with Ashley and had very limited contact with Mr. McDonald as well.
Okay, now you're asking for termination of parental rights today, is that correct?
That's correct.
And why do you believe termination of mother's parental rights is in the best interest of this child?
Due to parents' lack of contact, stability, and lack of services, as well as it is not safe for the child to return home to either parent. And I do believe permanency is the most important in this case, and safety.
Okay, had you reviewed the mother's prior history when you received the case?
Yes.
Okay.
Yes.
Does the mother have other children?
Yes.
And does she have care of any of those children?
This is where the case turns from weak to unrecoverable. The search efforts listed aren't just routine, they're exhaustive. Jail checks, address checks, social media, family contacts. When all of that leads nowhere, the court draws a harsh conclusion. This parent is effectively unreachable.
No, she does not.
Okay, and would you be concerned if the mother were to have any continuing contact with this child?
Yes.
Okay, where is the child currently placed?
He is placed in his paternal grandmother's home.
Okay, and is that Miss Nichols?
Yes.
Okay, do you have the opportunity to see the child in the grandmother's home?
Yes.
And do you have any concern regarding the care the child is receiving?
No, I do not.
Is Miss Nichols able to provide for the child?
Yes, she is.
Now you're asking that Miss Nichols be named permanent managing conservator of the child and the department be dismissed. Is that correct?
That's correct.
Okay, and why are you seeking the grandmother be named permanent managing conservator rather than proceeding with an adoption?
Grandmother attempted to get licensed, and there were issues with getting licensed. And just due to the child's age, and adoption would be more expensive for Miss Nichols, and she has stated that she did not plan to adopt anymore just due to the issues with getting licensed.
Okay, did you have conversations with Miss Nichols regarding if parental rights were terminated that she would not be able to get child support?
Yes.
And did she express an understanding in regards to that?
Yes.
Okay, and was she still okay with proceeding with being named permanent managing conservator of the child?
Yes.
Do you believe that your requests today are in the best interest of this child?
Yes, I do.
Okay, I pass the witness.
Okay, Ms. Kincaid, any questions?
Just briefly, Your Honor. A family plan of service was created for Ms. Dubois, right?
Yes.
Do you know whether she completed any of the services that are listed on the family plan of service?
My understanding is she did not complete any. I did staff with a previous worker before I was assigned the case.
Okay. Have you had contact with Ashley?
I have not.
Okay. And you were, remind me when you were assigned to the case?
August of 2025.
Okay. So it's been several months and you haven't had any contact with her?
That's correct.
Okay. If there were any contact information for Ms. Dubois, would you have passed that along to other parties in the case?
Yes.
Okay, thank you. I'll pass the witness, Your Honor.
Okay, Ms. Sapien?
No questions, Your Honor.
All right, and Ms. Zavala?
I have no questions.
All right, Ms. Powell, any further questions for Ms. Burden?
No, Your Honor.
All right, does the department rest?
And I rest.
Okay. All right, Ms. Kincaid, any witnesses to call today?
No, Your Honor, I haven't had any contact with my client, unfortunately. And so I have no witnesses. I have rest.
Okay, and Ms. Sapien?
I have no witnesses or anything else to present, Your Honor. I would just ask that my client be terminated based on the affidavit.
All right, do you rest?
Rest and close.
Okay. All right, Ms. Zavala, anything to present other than your recommendation?
No witnesses, I rest.
All right, and your recommendation today?
Your Honor, I do believe that it's in his best interest that the parental rights be terminated at this time and that Ms. Nichols be named permanent managing conservator. Kelly was able to visit with him in grandmother's home. He's doing very well. We've got no concerns about the care that he is receiving there.
All right, thank you. Okay, first of all, let me just say, Ms. Nichols, thank you so much for taking good care of this little guy. We really, really appreciate it. Sounds like he's thriving in your home, and I commend you for stepping up and doing this, and thank you for doing such a great job with him. All right, at this time, then I do find by clear and convincing evidence that it is in the best interest of the child, Jonathan Dubois, to terminate the parental rights between the child and his father, Rashad McDonald, pursuant to the voluntary affidavit of relinquishment that was executed and filed in the case, and the best interest of the child, both under Texas Family Code Section 161. I also find by clear and convincing evidence that it's in the best interest of the child to terminate the parental rights between the mother, Ashley Dubois, and the child, Jonathan Dubois, pursuant to Texas Family Code 161.001, subsection B1, the D, E, and N grounds, and the best interest under 161.001 B2. At this time, I will name Debbie Nichols as the permanent managing conservator of the child, Jonathan Dubois. I will also dismiss all court-appointed attorneys from the case. Counsel, just be mindful regarding your de novo and appellate timeframes. And if you're instructed to file a notice of appeal, please wait to do that until a final order has been signed and adopted by the referring court. All right, I appreciate everybody. I know some of you are in a real hurry, so I'll let you go. Thank you very much. We'll be in recess on this case. Oh, the first review hearing for those of, well, actually, we won't need that. Never mind. Department will be dismissed. I didn't say that, but department is dismissed as well. So
the judge's ruling isn't emotional. It's decisive and structured. Clear and convincing evidence is the key phrase, and it signals a high legal threshold has been met without hesitation. Both parents are terminated, but for different reasons, one by choice, the other by failure. That distinction matters. It shows the court evaluated each path separately and still reached the same endpoint. The grandmother is elevated to permanent managing conservator, which locks in stability immediately. The judge's praise isn't just politeness, it's reinforcement of the final outcome. Then comes the cleanup. Attorneys dismissed, department released, case closed, fast, clean, final. What started as a crisis at birth ends as a complete legal severance, with the system fully stepping out once a stable replacement is secured.